All right, good afternoon, everyone. Please bring out Ms. Simon. Julia, could you print me a copy of the verdict?
That you gave them?
Mhm.
You need another one?
Mhm.
You can.
Oh, Julia.
I'm gonna hold this one.
You hold that one. Oh, thank you. We're back on the record in SPCR 22-03364J6, the state of Georgia versus Leilani Simon. Let the record reflect that counsel for the state are present, counsel for Ms. Simon are present. Ms. Simon is seated with them. Okay, so we're back now, and the court will go into jury instructions once we bring the jurors in. Is there anything from the state that we need to take up at this point?
No, Your Honor.
From the defense?
No, Your Honor.
All right, you may bring in the jury.
Jurors in the room.
Thank you, Williams. All right, ladies and gentlemen, if you'll please have a seat. Good afternoon and welcome back from your lunch break. Were you able to follow the court's previous instructions? There were no discussions or research. All right. So as I told you before you broke for lunch, this is the time in which the court will give you the instructions that you're to use during jury deliberations. And so I'm going to first tell you once again, thank you for your time, your energy. This is, it's been requiring of your attention and your time. We could not do this without you, and this is how our system works. So, as to the indictment, you're considering the case of the state of Georgia versus Leilani Marie Simon. The grand jury has indicted Leilani Marie Simon with 1 count of malice murder, 2 counts of felony murder, 1 count of concealing the death of another, 1 count of false report of a crime, and 14 counts of making a false statement. The defendant has entered a plea of not guilty to this indictment. The indictment in the plea form, the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with the evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond reasonable doubt. The burden of proof rests with the state to prove every material allegation of the indictment and every essential element of the crime charged beyond reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce the evidence or to prove innocence. Just want to make sure. Okay, to resume, when a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded juror, fair-minded, impartial juror, honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize conviction of the defendant. You, members of the jury, are the judges of the facts. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. It also includes any stipulations, which are facts agreed to by the lawyers. Evidence does not include the indictment, the plea of not guilty, opening statements, or closing arguments by the lawyers, or the questions asked by the lawyers. When parties stipulate facts, this is the nature of the evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. As to direct and circumstantial evidence, evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned, though, about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the way you may give to either direct or circumstantial evidence. You will be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence, and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including witnesses' manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case in court by witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Prior statements. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Single witness corroboration. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Defendant's choice not to testify. The defendant in a criminal case may take the stand and testify and be examined and cross-examined by any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Statements that the defendant allegedly made to law enforcement have been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. Voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions of promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under the compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of her rights as discussed below, if applicable. Circumstances of the statements. You may consider the duration and the conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. Burden of proof as to voluntariness. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. Statement of defendant made on November 21st, 2022. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of her constitutional rights. Constitutional rights. If the statement was made while in custody and as a result of police questioning, You must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant has a right to remain silent. 2, if the defendant chose not to remain silent, anything she said could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with her at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questioning. I'm going to ask counsel to approach.
While they approach, I do not know what happened. I don't know how this ended. I'm assuming the jury just went out and they are now deliberating. Okay, hold on.
In resuming, burden of proof as to rights. The burden of proof is upon the state to establish that all the warnings of rights. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. Conditions precedent to consideration of statement. If you find, as mentioned above, that the defendant's statements were voluntary and that all of the warnings as to the defendant's constitutional rights were given, if required, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights where required, and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict, except for purposes of attacking the credibility of the witness or impeachment. Prior difficulties between parties. Evidence of prior difficulties between the defendant and Quinton have been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and Quinton. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. Identification and burden of proof. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant upon beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has sufficiently identified, if you do not believe that the defendant has been sufficiently identified as a person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as a person who committed the crime alleged in this bill of indictment. DNA. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Definition of crime. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute under this state in which there is a joint operation of an act and intention. Intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown by many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. No presumption of criminal intent. This defendant will not be presumed to have acted with criminal intent, but you must find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Presumptions and inferences. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the product of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such inference or inferences is a matter solely within the discretion of the jury. Guilt by mere presence. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Guilt by mere association. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Venue. The law provides that the criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Chatham County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Malice murder. For malice murder, the state must prove that the defendant 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as a term used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment and instantly a fit fatal wound would be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Malice. Malice may be expressed or implied or both. You may find express malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may imply malice when there does not appear to be a significant provocation and all the circumstances of the killing show an abandoned and malignant heart. Motive. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Felony murder. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. Aggravated assault and cruelty to child. Aggravated assault and cruelty to a child in the first degree are felonies, which I will define for you shortly. The state does not have to show that the defendant acted with malice to prove felony murder. Causation in felony murder. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Causation is a question left to you, the jury, to decide. Concealing death. For concealing the death of another, the state must prove that the defendant, 1, concealed the death of another person, 2, which hindered the discovery of whether that person was unlawfully killed. Simple assault, generally. A person commits simple assault when that person attempts to commit a violent injury to the person of another. Aggravated assault with an offensive weapon. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. An offensive weapon is an object that causes death or serious bodily injury if used against someone. Determining if weapon is offensive. In deciding whether an object is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, any other circumstances of the case. Cruelty to children in the first degree, malice. For cruelty to children in the first degree, the state must prove that the defendant, 1, maliciously caused, 2, cruel or excessive, 3, physical pain, 4, to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Voluntary intoxication, not a defense. Voluntary intoxication is not a defense to a crime if the defendant, when sober, could reason and distinguish between right and wrong, and she voluntarily became intoxicated and then committed a crime while intoxicated, she is responsible for the crime just as if she had been sober at the time she committed the crime. False report of a crime. A person commits the offense of false report of a crime when she willfully and knowingly gives or causes a false report of a crime to be given to any law enforcement officer or agency of the state. Making a false statement. A person commits the offense of making a false statement when she knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact, makes false, fictitious, or fraudulent statements or representation, or makes or uses any false writing or document, knowing the same to contain any false, fictitious, or fraudulent statement or entry in any matter within the jurisdiction of any department or agency of state government or of the government of any county, city, or other political subdivision of this state. Verdict generally. If you do not believe that the defendant is guilty of any of these offenses, or if you have any reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, however, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Chatham County, Georgia, did on or about the dates alleged in the indictment commit the charged offenses in the manner as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. Unanimous verdict. Whatever your verdict is, it must be unanimous. That is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. I have prepared a verdict form for you to use during deliberations, and it will go out with you. I don't expect you to be able to see it directly from where you are, but this is the verdict form, and it will state, or it states, we, the jury, find as follows: count 1, malice murder, and you have a choice. We find the defendant not guilty, or we find the defendant guilty. Count 2, felony murder, aggravated assault, we find the defendant not guilty, or we find the defendant guilty. Count 3, felony murder, cruelty to child in the first degree, we find the defendant not guilty, or we find the defendant guilty. Concealing the death of another, we find the defendant not guilty, or we find the defendant guilty. Count 5, false report of a crime, we find the defendant not guilty, or we find the defendant guilty. Count 6, making a false statement, we find the defendant not guilty, or we find the defendant guilty. And that will be the same with counts 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, and 19. Each of those counts is making a false statement. And for each of those, you would find the defendant not guilty, or we find the defendant guilty. This will be signed by the foreperson and returned to the court. The court has no interest in the case. By no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws giving you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. Responsibility for sentencing. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. Deliberations. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should only do so after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Juror use of technology. Obviously, during your deliberations, you're free to talk with one another about the case. During your deliberations, however, you must not communicate with or provide any information to anyone else by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, tablet, or computer, the internet, any internet service, any text or instant messaging service, or any internet chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, Twitter, Instagram, Snapchat, or TikTok to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. I am going to release you now to retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in this case. You are excused to the jury room.
Jurors are exiting.
Oh, just a moment. Very important. So we have 4 alternates. The 4 alternates will not deliberate with the other 12 jurors. Your presence here is important. We could not do it without you, but 4 of you will be remaining. And I think that's 1 through 12 are the primary jurors. Okay, so 1 through 12, please step to the jury deliberation room. And as to the 4 alternate jurors, you will go next door. Is next door free? Okay, thank you. So 1 through 12, please retire to the deliberation room. And ladies and gentlemen, before you leave, I just want to say thank you for your time and attention. It is important for the court to have alternates. The same rules apply to you. Please don't discuss the case with anyone. Don't use any media to communicate with anyone else. Don't do any research, okay? All right, thank you very much. Thank you. Thank you, Williams. Okay, everyone may have a seat. Okay. Anything from the state?
No objection to the charge, Your Honor. If that, is that what the court was inquiring about? Yes.
And Mr. Purse?
Yes, ma'am, one matter.
Yes.
On behalf of Ms. Simon and pursuant to Official Code of Georgia 17-8-58, parentheses A, close parentheses, the defendant objects to the court's charge on prior difficulties between parties. Yesterday during the charge conference, we made some preliminary objections, but I think that statute requires us to put the objections on the record after the charge. Our position is, there are circumstances where that charge has application, and this is just not one of them. It's if people are feuding or something and there's a crime committed, it fits in that circumstance. This is different than that, and we object to being provided. That's our only objection to the charge provided by the court.
Thank you, Mr. Purse. Your objection is noted.
Thank you, ma'am.
And At this point, I guess we will. Oh, yes. Coming up, take a look at the evidence. I know there was a preliminary review of the evidence.
I can run it up under the table. I don't think that extension cord will reach all the way.
Yeah, I just unmuted my mic. Hold on, guys.
Sorry.
Hubby's doing something for me. Give me 1 second. So you guys know how I'm trying to like find easier ways to keep coffee. I have this water maker thing. It makes hot water for tea. And we're plugging it in. You can keep the coffee hot in it. And I didn't realize that. So I won't have to get up and get coffee. We're just going to try to get the cream and the sugar again without forgetting about it. We're on verdict watch, huh? I guess they're taking the evidence. They're going to hand it off to the jury. They asked the jury not to start to deliberate until they get that evidence and all the papers from the trial. I have a feeling this is going to be a while because they're going to have to go through each and every single one of them charges. And there's a lot. She read a lot of charges off. Leilani looks worried. What do you think?
Yeah, well, should
She should be.
be. Oh, yeah.
I wasn't asking you, but thank you. Don't unplug my computer, please.
Your computer is there.
Okay.
I don't remember plugging it.
Oh, is it on? We were going to put that on. Hold on. I hope they're getting out. I really do. I would think that would be on my wall, but it ain't. Okay, hold on. Doesn't look like it started. It looks like they're going over some stuff, but we'll watch. I can't. It's not allowing me to go back, so we got to watch it from where it's from. What do? Put it on a temperature?
Let me put it on more. There you go.
All right. Thank you. I got coffee. All right. We'll just put this on and watch a little bit.
There you go. Finish what I'm doing here. Get a shower. What do you want? Michael Jackson? What is it?
Dude, my cache needs cleaned or something. If I do that while I'm live, I think.
Pretty almost every day. Certainly by the time I was 7, I was playing almost every day. And really, my dad was focusing on tennis
Sorry.
and soccer because I was having a very hard time with swimming.
I'm going to mute.
I might play several hours in a row, maybe like 4 hours, and then we would switch and play some soccer, or he would go over that.
Running Bear, this is live. This is the district attorney to hold a news conference on the Menendez brothers case. So we're just waiting. And I'm sorry I refreshed the wrong page. That's where I went. I hope they go free too. They deserve it, I think. I think they did their time. I'm not going to say they shouldn't have been punished for what they did, because you shouldn't have killed them. You should have went about it a different way, right? But I think they've spent plenty of time behind bars. I hope today we get to see them walk out. Okay. Damn it. Here's another one. U.S. Today. Let's see.
Voting by mail is secure, and requesting a ballot is easy. Visit pa.gov/vote-by-mail to request your ballot today.
We'll do this.
Pennsylvania, the election's here. It's time to make your voice heard. You have the power to decide, and you can comfortably vote by mail, avoiding the lines and saving time. Make your plan to vote by mail at vote.org.
These may look like dentures or partials, but in fact, it's some of the newest dental implant technology.
Man, I should have cleaned my cache. This is driving me nuts. Hold on. There has to be a good one.
You're live now from Fox. I'm your host, Carla Hara. We're still awaiting a press conference to get underway over in Los Angeles. This is in regards to the case against
Every time I do something.
the Menendez brothers and whether or not they will be resentenced. I do want to put up a tweet, though, here from the Associated Press, as they are reporting, take a look at this, that LA prosecutors want Eric and Lyle Menendez resentenced in the 1989 killings of their parents. That's according to officials and what the Associated Press is reporting at this moment. Back out to this live feed, and I do want to kind of box it up here with some footage from the brothers way back when in the 90s, excuse me, when this case first garnered so much attention.
Guys, I might have to end my stream and come back. Let's see how this works. If I disappear, don't go nowhere. Just stay here for a minute. It might log me out and let me log right back in. I gotta clean my cache. Let's see what happens. Oh no. It worked. All right. 1 second here. I appreciate you all being patient. I might have to relog in over here. Hold on.
Kitty Menendez. The brothers said they feared their parents were about to kill them to stop people from finding out that their father, Jose, had sexually abused Eric Menendez for years. The brothers' extended family members have pleaded for the release, saying they deserve to be free after decades behind bars. Several family members have said that in today's world, the brothers would not have been convicted of first-degree murder and sentenced to life based on those sexual abuse accusations against their father, who they killed. The Menendez brothers were tried twice for the murder of their parents, with the first trial ending in a hung jury. Prosecutors at the time contended that there was no evidence of molestation, and many details in their story of sexual abuse were not permitted in the second trial. The district attorney's office also.
Or maybe it's just their stream. I don't know. I'm getting mad. I'm getting just as mad as Running Bear. Sorry. I don't want to do the Associated Press because they've been suing people. Oh, hold on. Let's try this.
I analyzed 10 websites that were creating SEO content using AI.
Here we go. Garagos is there? I forgot he was on their team. Look, it's doing it again. It has to be their stream. It can't be me. I'm trying to fix it. Yeah, Garagos is their lawyer. He was back then, too. I didn't know he was. Yeah, I did. I knew. I'm not thinking. I don't know why my damn computer keeps doing this. I'm not going to make the screen large. I'll leave it small. Oh, you know what? I'll fix it if it does it again. I know what it is. I got to change the quality, maybe. Welcome back, Crystal, Suzette, Little Dev, everybody who's stayed here. Those who just came in at the end of Quinton's, thank you for being here. I think Jody was talking shit on me. I want to go watch her. We're on jury verdict. I have to go. Did they leave that stream up? Let's go check that out. Yep, verdict watch. So we'll leave that there. Nope, look, it's doing it again. All right, hold on. Sometimes if you play with the quality, it fixes it when it does this. I don't know why it's doing this. I'm getting angry.
Let's get real. It's hard to live up to that mug. Like that time you forgot the diaper bag.
Years in the making, and now we are going to find out what exactly the opinion is. So we are learning right now that the family members are in fact meeting with the district attorney's office and prosecutors, who again are expected to say that Eric and Lyle Menendez should be resentenced. Now, whether in fact that means that they have had time served and that they'll be free. Certainly their lawyer, Mark Garagos, was hoping for something like that to be announced, that Eric and Lyle Menendez would be home to celebrate Thanksgiving together as a freed person. But clearly we don't know that yet. And we're certainly
It can't be every stream. I'm getting mad. The hell is going on with my computer? I don't know why it's doing this. It can't be like the news broadcast. I could see it being... I cleaned the damn cookies.
Pennsylvania, your mission is clear. It's time to vote.
They forcing commercials, voting commercials. It's probably what they're doing.
Go to vote.org to make a plan and let your voice be heard. Whether by mail-in ballot or on election day, make your vote count. Get more intel at vote.org today to see if voting has begun in your county.
It's Trucktober at Team Ford Steubenville. Join us for
guys, if you guys
deals on a full selection of trucks now through the end of.
I'm the first one to graduate in my family. DeVry really helped make it all achievable.
Nathan Hochman, the challenger for the LA District Attorney's Office, I should say, has been saying that Gascon is using this case to promote his campaign again. So when we talk about the backdrop of all this, the bigger question here is this politically motivated? We don't know, but certainly this case getting another look here in current days and different public opinion, obviously, surrounding this case because the times are different. If you remember back in 1989 and throughout this trial, if you followed that, many people were saying that it is impossible for men to be sexually abused like this. It wasn't that common or spoken about. So clearly, again, a very different social climate we're talking about. But why did it take so long?
I give up. Hold on. Or not. God knows what's going on with my computer right now. I'm getting, maybe it's because I have the other live stream on. Let me shut that off. This is really frustrating me. I've never had something like this happen.
There's a couple chairs up there.
There's chairs here. All right. Yins are just gonna have to fill me in, I guess. I don't fucking know what to do here. I'm getting aggravated. I don't know why my computer's fucking up and it's gone.
They're both going to be resentenced the day the family has been waiting for quite some time.
Let me try to just stay on this tab and not come off. I can't see chat. I'll grab my phone. I bet you I could see it on my phone. Okay.
So any moment now, we're expecting to see them walk out.
I had to touch a fucking button, right?
Eric and Lau Menendez case in terms of the Netflix documentary and other public interests that have been surrounding these two brothers who have been behind bars for decades now. And it's uncertain what this resentencing will mean. Will it mean that they are free because of time served? Is that immediate? Will they be able to go home for Thanksgiving? That's certainly something their attorney, Mark Geragos, has been calling for. Or will that mean kind of a separate resentencing trial where we'll see if their sentence is shortened or not? So these are all the questions that are surrounding this announcement that's expected to begin any moment now, according to the instructions that we got just moments. All the questions that are surrounding this.
It did it again. Everyone seems to be waiting. Don't sweat it. We'll eventually see it. Let me go try something different. Maybe. I don't know. I've never had this happen. I got my phone up. I'm looking at chat from my phone. Let me
The
try.
state and the defense rests in the Leilani Simon trial. Folks, let's take a look.
See, I just put Duty Ron on, and it's not messing up. It has to be something with that, right? My fucking computer. Here, let's go checking on her. I think she was talking shit on me. Go ahead, bitch. In my opinion. Of course, black screen.
Slight, subtle, but there. As he's talking about those boys and how their pridefulness.
It has to be that. Just looking at that. I don't know.
Shifts again. Just a shimmer of it.
We'll go back and try again in a minute. Let me know if they go live.
Tells Dr. Phil how they, but they don't associate. Just good church people.
Okay, let's rewind. I want to go back.
Shimmer.
She been on all day. Nope. Come on now. This is ridiculous. It's embarrassing. I don't know what the hell is going on with this computer. She's on black screen. I'll just come talk to you guys. Oh, so what do you guys think of the Leilani case? I'm going to go turn the Menendez stuff on in a minute. I just need to cool down because I'm getting very angry at my computer right now. I've never had this happen while I was live before, that every video won't freaking play.
I just want them to come back with a verdict quick, but I feel like it's going to be a while. See, there it goes. It's doing it again. You know what? I'm going to end this stream and go re-clear my cookies, maybe because it did it while I was live. And I'll just start a 4th stream. I hate doing that. I'll be right back. Peace and love. See you in a few.